Hi, welcome to Help Solve the Case. You are here watching day 2, the DNA portion of the Tyler Robinson trial for the Charlie Kirk killing. If you don't know me, my name's Christine Burke. I'm a retired police detective and sergeant. I am a law enforcement expert witness and forensic genetic genealogist. And I love everything court. I started out as a paralegal a long time ago, and I've also been a long-time defense consultant. And I love everything legal. I love the court system. And as you probably can tell, I love talking about it. And I'm really grateful to have you here. I really would appreciate your help if you would subscribe to the channel, because part of what I do here is to raise awareness and raise funds for my donated genetic genealogy services for police to help identify our over 15,500 unidentified human remains cases and solve the over 250,000 unsolved crimes across the United States. That's my mission and my purpose. And thank you, thank you, thank you for being here. I love all the support. These cases and these trials help educate us all about what goes on in the criminal justice system. And as we'll get into, I'll talk about the DNA. I love DNA. Those are my favorite letters of the alphabet. And I'm going to talk about what really happens in the court system from all perspectives. Okay, we're not taking one side or the other, but we're just looking at what is presented. You'll hear me talk about a Netflix show. Somebody's putting on one version over here and another version over there. Which one are you going to like best? Meaning you, the viewer, and you, the jury, if you were in the trial. And it's a chess game between the prosecution and the defense. And we've got the judge and the jury involved. What is going to happen? Who are they going to put on the team? What are they going to present and why? And that's what we're here to talk about. I'm hopefully going to give you some insight from my background in all those areas. So we will get started. Thank you, thank you, thank you for being here. I am doing this separate video on the DNA because there were so many things that they were talking about that I wanted to speak specifically and show you those areas. So pardon me while I do my screen shares and stuff and find the appropriate areas, and we will go from there. So thank you again for being here. Please put your questions in the comments, and I will do my best to answer them. Okay.
And then I'll have the screwdriver that we've spoken about and the towel that we...
Okay, they are getting ready here. This is Sergeant, and I don't want to get her name, Falomina. I don't want to get her name wrong. And she is up here talking about, she works for the Utah Department of Public Safety, and she was initially on scene that night. We heard that from Detective Hull, and she was charged with the forensics, the crime scene, and that stuff. And she's talking specifically about items that were collected. We talked about the screwdriver, and we talked about the gun, and there was also a towel. So we're gonna hear a little bit about that. I want to show you this so that you know specifically what I'm referring to when we talk about different parts of this. Up there.
I moved it. Okay. If you'll go to, Kimberly, if you'll scroll down to, so we're on page 1, where the screen will show items 7 and 8.
Okay, so they're talking about items 7 and 8. And I believe that is the towel and the screwdriver. Okay, these are evidence items that were collected and tested.
Sergeant Falomina, do you see the lines that say item 7? That line?
Yes.
And we read that portion of the report that describes what item 7 is.
Item 7, towel from around Mauser rifle, serial number 8863.
And there's also some other identification numbers. Is that the towel that you found with the rifle that day?
Yes, it
On
is.
September 10th?
Yes.
Item 8. Will you read what that says is a description of item 8?
Item 8, screwdriver from perch.
And is that the screwdriver that you described that was collected from the rooftop?
Yes.
Okay.
Okay, so they're talking about that was collected, and they're going to talk about here. Let me see if I can get it on the screen. She's going to talk about the identification or let me get my language right, because they're being very particular here about language. Talking about the inclusion of Tyler Robinson as a person of interest in this case and how they determined that. Okay. And they're citing, it's kind of very hard to read here. I'm not sure if this is going to be published to the public in a different format, but they're giving a percentage here that they're going to read. Okay. They're talking about item 7 up here and item 8 down here.
Yes. Male DNA was obtained from item 7 sub 1. Item 7 sub 1 was interpreted as originating from two individuals, one of whom is twins. The DNA results from items.
Okay, so they're saying that the DNA, right? And this is the first time that I have heard this. I have not followed this case too closely, as I've told you, but this is the first time that I heard that DNA from twigs is also on the evidence items. Okay, and that's what she just said. All right, so item 7, she said his DNA is on there. Okay,
7 sub 1 and what are 1.7 octillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item.
Okay, so they gave that number, that octillion number, I believe it is. Let me back up a little bit. Sorry, it's kind of hard to stop this. Yeah. 1.7 octillion times more
likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
Okay, 1.7 octillion times more. They use it's called probabilistic genotyping. Okay, so that is the statistic that they're going to go with, and it sounds kind of boring and maybe a little confusing right now, but when we get to the rest of the video, they're going to talk about it. So what she's saying here is that it's 1.7 octillion times more probable that the DNA belongs to Twigs and Robinson versus Twigs and a unknown related person. Okay, so what that's telling us is initially on item 7, there were at least 2 contributors, and one was Robinson and one was Twigs. And who do we know Twigs to be? Twigs is reportedly the roommate of Tyler Robinson. Okay, and so both of those DNA, I want to be careful with my wording. DNA profiles were identified or found to be probable. We're going to leave that there. Okay, now they're going to go down to item 8.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same 2 paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from 2 individuals, one of whom is Twigs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twigs and T. Robinson are contributors than if Twigs and an unknown, unrelated person are contributors.
Okay, so this is important. So this is 30 quintillion. Okay, that I don't know the difference between a quintillion and an octillion. Okay, but those are huge numbers, right? We don't hear those in every day. And what they're saying here, the importance of what they're saying is the way that they phrase this, and we're going to get into that. We're going to talk about it, is that they're saying it's more likely that it's Robinson and Twiggs than Twiggs and somebody else, an unrelated person. Okay. So we got to take that. We got to take that right there.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was
Then results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel, and the screwdriver. That's all.
All right. The court will overrule the objection and allow a brief an overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors thing in comparison.
yes. Yes.
What is a buckle swab?
One was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. A couple of foundational questions before we finish for now. First off, do you know who Twiggs is? Then results that will be discussed by the other expert, as well as the results of the items we've discussed, the towel, and the screwdriver.
So the court will overrule the objection and allow a brief overview of it, not going line by line, page by page. So if it is brief, I'll allow that.
Thank you. So if you'll read item 7.1 to the word contributors.
Overview of it, not going line by line, page by page. So if
More likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Thank you. Let's skip down to item 8.1. Do you see that bolded and underlined line there?
Yes.
And this is relating to swabs of the handle area of the screwdriver. Is that right?
Yes.
Will you read those same two paragraphs there? Male DNA ending with contributors.
Male DNA was obtained from item 8 sub 1. Item 8 sub 1 was interpreted as originating from two individuals, one of whom is Twiggs. The DNA results from item 8 sub 1 are 30 quintillion times more likely if Twiggs and T. Robinson are contributors than if Twiggs and an unknown, unrelated person are contributors.
Okay, thank you. Couple of times.
All right. He continues. He's going to ask her to identify who these folks are.
Questions before we finish for now. First off, do you know who Twiggs is?
Yes.
Who is Twiggs?
Twiggs is Lance Twiggs. He was a roommate of Mr. Tyler Robinson.
And do you know if Lance Twiggs's DNA was obtained for comparison in this test?
Yes, it was.
And how was that DNA obtained?
It was obtained by law enforcement officers.
And was that by a buccal swab?
Yes.
What is a buccal swab?
A buccal swab is basically like a Q-tip or a swab that we'll just place in someone's mouth and just scrub the inside of their mouth to obtain the cells.
And then that Q-tip is then packaged and sent to the lab for testing and comparison?
Yes.
And was the defendant, Tyler Robinson's DNA, also collected in the same manner?
Yes, it was.
Okay.
Okay. So interesting here that they're talking about the buccal swab, however you pronounce it, that it was collected from Twiggs. Now, typically, depending on the state, and I am not up to date about Utah, whether they collect upon arrest or whether there was a search warrant or whether they collect upon conviction. But the fact that they have it from Robinson, I would assume that's normal. They would have gotten it from a search warrant pursuant to the law for DNA collection with him as a suspect. Or, and the problem here for me is that they got Twig's DNA. And to my knowledge, I could be wrong because I haven't been following this case, Twigs was not arrested. So, they're getting his DNA. And what are they getting his DNA for? And what role will that play? All right. So we're going to watch that. We're going to find out. So what's going to happen now is they had to jump through. They weren't supposed to do the DNA so early, but they're going to jump through and they're going to put the FBI witness on because apparently she had to go to another case. So she needed to testify early. And that's why I'm a little behind because I wasn't expecting this and wanted to pay particular attention to the DNA because that's what I do most days, work on DNA and forensic genetic genealogy and investigative cases. Okay. So.
Thank you. Nothing else.
Mr. Burke, cross-examination.
A day, 7 days a week until examinations were complete.
It's up on your voice, okay?
Hey.
Okay.
Your witness.
So now we have, this is interesting. This is the person that, right, they had to reorganize the witness chart. This is someone from the FBI that is testifying for the defense. Okay. Very, very interesting here. And I want to go to my notes because I don't want to drive you guys too crazy going back and forth with the video. But I think that it's very important here. Okay. So the fact that she's a defense witness tells us a lot. It tells me a lot. Okay. That they think they found something. All right. And they're going to go for it. The defense is going to go for it, which we will see. So, it's interesting here too. And one thing I wanted to talk about, I promised this in the comments, that I don't think that they're bringing their A players, okay, to this hearing. And why would that be? Well, we're looking at it from both sides, right? I look at it from prosecution side, defense side, civilian side, all sides. From either attorney side, specifically the prosecution, when you have any type of hearing, you love to have a hearing. If you're a participant in a court case, you love to have a hearing because you're going to get information. Okay. It's kind of like sneaking into the other team's locker room or getting a glance at their playbook. All right. So you know what's on their roster and what they're bringing to the table. So in this case, they're putting evidence on, but it seems to me, I'm getting the feeling that they're not bringing their A players. And why not? Because when somebody testifies under oath, one of the things in a case, right, from a defense perspective, from a prosecution perspective, you want to impeach witnesses that could be problematic for you. You want to impeach a bad witness in general, but a witness that is problematic for you, you want to impeach them. And how do you impeach them? With credibility issues. Okay. Well, you said this thing here, and then you said this thing here, and then you said this thing in your report. And which is it? Were you lying? Were you telling the truth? All right. So because there's a preliminary hearing here, if they bring their A players and their A players get benched, they got a problem. So it's just my feeling. I'm not an attorney, but based on what I'm hearing and a lot of the answers of that, I don't know. We've got these 1102s that are coming in as affidavits instead of these actual witnesses. To me, they're concerned about impeachment. Just my theory. Okay. And again, I will make full disclosure. I am not on one side or the other. I'm not a cop trader. I'm not a defense trader. I'm not, a conspiracy theorist or whatever. I am just stating the facts as I see them based on my many, many years of expertise. And because I find it interesting, and I hope that it's enlightening to you guys, maybe helps some of you understand a little better, and we all help each other understand what is currently going on in our criminal justice system. That's it. Okay. So one of the things when I saw that this was an early defense witness from the FBI, I was like, oh boy, let's see what's going to happen here. And they've raised some really good points. Now, one of the things here, she's going to talk about her background a little bit here. Let me go ahead and play it.
We're going to need the monitor switched over to our side if we While we're doing that, good afternoon.
Good afternoon.
Tell us your name, please.
Hi, good afternoon. My name is Amanda Baker. My last name is spelled Baker.
Miss Baker, what do you do for a living?
I am a forensic examiner in the DNA casework unit of the FBI laboratory located in Quantico, Virginia.
And how long have you been a DNA analyst at that location?
A little more than 10 years.
And just in general, what are your duties?
Our duties are to manage a case. When a case comes into the DNA casework unit, I will review any information associated with that case. I will review any evidence that is submitted for that case, determine which items of evidence need to be tested and which tests need to be performed. I will then create something called an exam plan. You can think of this like a to-do list to let the biologist know which items I need tested. Once that testing is complete, I will review all the data, draw conclusions in the form of a report, and then testify if needed.
Okay, so it's a little unclear. I've never worked in the lab, right? I've only worked on the investigative side, although I interact with lab people, case managers, things like that. It's a little confusing to me when she talks about her role as case manager, because what she just described is that she's not actually doing the work. She said she's not the biologist, okay? But later, she's going to testify about making some calculations and stuff. So it's a little confusing to me exactly what her role is supposed to be. How technical? Like, do we really have the technical people that I would expect to be here? To me, she sounds more like the case manager than the actual biology specialist, but I'm not sure. Okay, they didn't talk about her background necessarily and her training. So I was just a little like, okay. And again, why is the defense calling the FBI in? All right. So she talks about a couple things here. I'm gonna save, like I said, the screenshots for the nitty-gritty. One of the things that she talked about was that she received the evidence on September 11th. And they talked about how quick the FBI's crime lab typically completes work. And I think this is interesting because we've been talking about the FBI crime lab all over the news in at least one high profile case, how fast they're going to work, why it needs to go to the FBI, blah, blah, blah. So I thought it was interesting. She says it could be between 90 days and 200 days to get evidence processed. That is almost a year. And let me tell you, for our crime victims, for anybody involved in the criminal justice system, we need more funding to make our police agencies work better. This is unacceptable to me, having been in the police department and having to provide answers to constituents. That's unacceptable. That's unacceptable. Okay. She says it's typically, it should be unacceptable to you, but that's your opinion. It's just my opinion. So I really would like to do something about that. We need to get that moving, right? This is our preeminent law enforcement agency. taking 200 days. That's almost a year. She says typically it's 180 days. Okay, that's 6 months. That's not acceptable. That's not acceptable. What if there's a criminal running the streets? Again, just my opinion. She said that this case, though, came in at the priority level, and so they worked it 24/7. So from a police perspective, that's awesome that that's available. But from a victim perspective, that you're not a victim in this case, why does this case get 24/7 access? Does that 24/7 access affect the rest of the cases, that the rest of the cases are taking 180 days? I'm just asking thoughtful questions, right? Are we okay with that? Are we okay with that? Why does one case get prioritized over another case? Every victim deserves the same justice, right? Every defendant deserves the same due process. Just asking the question. Okay. Let me find this particular area here.
Ms. Baker, in this case, were you requested by the state of Utah to do certain testing?
Yes, I was.
And when
Mr. Bird, are you requesting it to be displayed to just your screens or to all screens?
No, since it's an evidence trial, I'd like it displayed to the public.
Okay, let's go ahead and put it on the main monitor as well.
Okay, could you go to page 6, please? So highlight the third paragraph. This is your report.
That testing is complete. I will review all the data, draw conclusions in the form of a report.
And when were you called upon to do that testing?
That was September of 2025.
And do you recall when the case first came into your lab?
I believe we received evidence the first time was September 11th of 2025.
And just in general, when the FBI, your unit receives evidence, and just in general, when the FBI, your unit receives evidence for analysis, is it true that the turnaround time is about 200 days?
A day, 7 days a week until examinations were complete.
And is it true that you were conducting the analysis as the evidence was being inventoried?
That is true. Because of the high profile nature of this case, an item of evidence would be submitted to the lab. It would be inventoried by our evidence management group and then sent to the various units for testing. For example, the DNA casework unit. We would begin testing as additional evidence was being delivered to the FBI lab.
Now, as a result of your analysis, do you produce case files
Yes, I do.
and document your examination in other ways?
Yep.
Do you have your case file with you?
Yes, I do.
Okay. And in your case file, are there?
All right. So now they're going to talk about some notes and how she came to do the testing in the way that she did the testing. And again, I think the details here are very enlightening and important. And that's why I'm going through these particular spots. So I appreciate your patience so that I can provide the commentary and talk about these particular areas. And I'd like to know what you think too.
Notes, conversations that you have with people that are relevant to your testing.
Yes, that's called our communication log.
Now, do you have your case file there in front of you?
Yes, I do.
I think the pages are numbered. So I'll ask you to go to page 22 of your case file notes. And if I could direct your attention to the bottom of that page, there is a communication log entry dated September 13th. Do you see what I'm referring to?
Yes, I do.
And would you read to the court what your entry is for that date?
Yes. This is my communication communication entry on September 13th, 2025. Oh, spoke with FBI Special Agent Folger and Utah SBI SA Dave Hull. Gave technically reviewed results that Robinson was included as a possible contributor to the DNA from the towel and the screwdriver. We discussed the additional examinations conducted by DCU, and they both agreed that no additional immediate comparisons are needed at this time. All remaining comparisons will be in the laboratory report.
Is that an accurate reflection of what you told the agents at that time?
Yes, it is.
Okay, so from that part, they are making the and you can't use, we're going to get into the language, the inclusion of Tyler Robinson, and that no further testing, what I thought was interesting, no further testing was going to be needed. Okay, so I thought that was interesting. We'll get to more of this later about why this is important. But it sounds to me like they felt they had what they needed, take that how you want it, and they weren't going to do anything else. So that raises the question to me, putting on my defense hat, was there more that could have been done? Was there more that should have been done to confirm the results that they had? Okay. Okay, now we are going to get into the part we're going to start talking about some technical language and some DOJ policy. I'm not sure I'm going to get into, I'm not going to show it because it's kind of, I don't know, kind of overkill if I show it, but I really believe that it's important for several reasons. So while they have Ms. Baker on the stand, the defense, right? This is the defense's witness. They get into this DOJ uniform language for testimony on reports for forensic DNA, autosomal testing, or whatever it is. I couldn't get at the whole thing. And they're talking about the standards here and the limitations, the quote, limitations of opinions being expressed. And why is this important? So those of you that know from my forensic genetic genealogy training and videos that I have an issue with the DNA policy as it applies to forensic genetic genealogy because it is limiting. I feel it is wasteful. It hasn't been updated since 2019. And I believe it hampers police investigations in using forensic genetic genealogy. Okay. It is guidance. And I have a whole thing that I teach if you're a law enforcement officer that's watching this, a whole reason that I go into this, why I feel it's, I don't want to say it's inappropriate, but why it hampers. And so I just don't like it. And I bring that up because here we see this DOJ language, okay? And basically what it's talking about for you to take a look at it, if you want, sorry, I don't block the microphone, is that Which Baker said that there are, quote, limitations of opinions being expressed. Now, what is, right, when we look at it from the defense side, we look at it from the prosecution side, but we look at it from the defense side, here's my question, shouldn't the defense be able to ask the questions that it needs to get the answers that it needs? Should the witness be restrained by a policy or a guideline? And I haven't read through the guideline, but should they be restrained on what they can say and what they can't say? When it comes to an expert, all right, most states have language around the elimination of prohibiting what experts can do and can't do. For example, in the state of Arizona, where I am an expert, I cannot be limited monetarily or otherwise about how I come to my conclusion about my expert opinion. I cannot be interfered with. I am an independent expert, okay? So just raising that question here that we have Ms. Baker, things to think about, not maybe just this trial, but other trials as we learn about these things. Do you think that somebody should be limited by the federal government or otherwise about their expertise and what they can talk about? Okay. It was talking about how to frame testimony and what statements were not approved. Okay. And one of the statements was, quote, absolute identification, end quote. And they talked about not being able to use the words, quote, reasonable scientific certainty, end quote, or, quote, reasonable degree of scientific certainty, end quote. And if you watch these trials, like you're here for, you've heard those words before. You know how the experts testify. And so it sounded to me, again, I haven't read the policy, that they're being limited. I don't like that. Don't limit. You're going to hire me. I have my certain expertise. Don't limit me on what I can say and what I can't say and how I can come to my opinion about what I deem necessary to look at to come to my opinion, right? We're looking at some of the state's witnesses here and the defense witnesses, and we're saying, well, what about this? Didn't you look at this? What about that? Didn't you do that? Okay. So that's my take on that. Okay. It also says something about they may not state that results are infallible. Okay. Or that they can have a 0 error rate. Okay. So what does that mean? Stuff happens. Errors can happen. All right. So then the defense attorney asks her, well, what are some sources of error? And she said, of course, human error and DNA testing, how the items are brought through the system and how evidence items are collected or tested. Yes, we know about all of that. That's why we're going through these things. Okay. Then going back to next, and if you guys want a full video, I could do the whole video of a play-by-play and I can overlay it and quote it. I'm trying not to be too tedious here to get you the information. If you want to know further, we can do that. They're talking about how somebody gets included or excluded from results, okay? And they're still talking about these policies that tell Miss Baker and her people, the federal people, how to do their job. Okay. Now, inclusion means that somebody is included in a result, that is a valid result for that individual. Okay. They should be considered if it is an inclusion, right? Excluded is not present. Okay. We'll talk about that a little more. But here, it says, quote, support for an inclusion. This is the language of this document. Support for an inclusion is an examiner's conclusion that there is evidentiary support for the inclusion of a known individual as a possible contributor to the DNA typing results obtained from an evidentiary sample. Okay, like what? Like yes or no? Is it them? Is it not? Okay, so they're putting it, this policy is putting it in examiner's conclusion that there is evidentiary support, evidence to support it, the inclusion of a known individual as a possible contributor, not the person, a possible contributor. Okay. Now that's going to be important when we get to it a little bit later. So they also talked about how an examiner shall not assert that a likelihood ratio, that was the octillion, what was it, quartillion, octillion, the 1.7 and the 30 quadrillion or whatever. That's a likelihood. So it says an examiner shall not assert that a likelihood ratio of any magnitude provide an absolute identification or source attribution of an individual to an evidentiary sample. Okay, so what they're saying here, and I think these are very vague, right? I talk about semantics a lot in my video. This is very vague wording, okay? But what they're saying here is that an examiner shall not assert that a likelihood ratio, okay? So when they give you that number, that 1.7 octillion or quadrillion, whatever it is, they shall not assert that that number provides an absolute identification. Okay, so they're not saying that that is 100% the person. It's just a ratio. Okay, so what does that mean? Are you taking that number as an absolute identification? Okay, because they're saying no, you can't tie those two together. That just because that number is there, it is not an absolute identification. Or can they attribute the source of the evidentiary sample, okay, the DNA from the sample, to be that person? Right? I think that says a lot. Okay. They're not firm on that number. Okay. When they give you that ratio and that number, it is a likelihood ratio, and that's it. They're not saying that that thing came from that piece of whatever, and they're not saying it's definitely the person. So they talked about how they're not implying that other numbers provide an ID of Mr. Robinson or Mr. Twiggs. So what do we do with that number? And I'm telling you, this is STR testing that has been accepted in the court. We may, the way the defense is going, we may see a Fry or a Daubert challenge. Okay, we may see that with the technology because the defense is hammering hard. Okay, they then ask about a quote formal activity level. And you know what? Let me take this off the screen share so you guys can see me. Okay, they're talking about a formal activity level. And what is that? Okay, so coming into evidence and trials and things, coming into our universe, our forensic universe, is a bit of a change. Before, we typically felt, well, DNA's there, right? So, potentially the person must have been there. Okay, that because the DNA is there, the person must have done something to get their DNA there. They might have been present, for example. And I've talked about it in other videos where there's a new perspective or in a more emerging perspective now about the fact that, just muting the live hearing, that you can't just say because DNA is there. The more we learn about DNA and how DNA gets everywhere, we shed everywhere. You can't just say that just because the DNA was present means the person was present, because we have transfer DNA. Okay, DNA can get everywhere over a number of reasons. And so there is more attention being paid to activity level. Okay, does this result mean X person was present? Okay, and that's huge. It is something to think about. Now, per this policy, they cannot give an activity level. Okay, so again, just because the DNA is there doesn't mean that the person whose DNA it probably is, let me rephrase that, possibly is, doesn't mean that that person had anything to do with it, because it could have been transfer DNA. And we've got, remember, we've got two contributors here. So we're going to think critically. If they're saying that, like, Twiggs is not arrested, and they're saying we've got Detective Hull at this point saying that it's Robinson on the roof, then how do we have two contributors? If Twiggs was not there, because Twiggs is on 7 and 8, according to Miss Baker, which we will get to, she says positively that Twiggs is contributor 2. It's possible that Robinson is contributor 1, but Twiggs is contributor 2, and the defense is going to hammer that home. Okay, so So then how did it get there? How did it get there? Was it transfer or was the person there? Right? So it's kind of a what's good for the goose has to be good for the gander. So we have to look at that, okay? Quote, just because DNA is on an item doesn't necessarily mean that an individual touched or utilized that item. End quote. Okay. The defense starts asking, and again, let me know if you guys want me to go play by play with the video. If they go back and forth, it's kind of tedious. I would have to do a complete run through so I could do it through the whole fell swoop and stop it as it goes. Be about, I don't know, 4 hours or so. Let me know if you want me to do that. I can do that because we can hit each count specifically. Or if you have questions and you want to send me little snips, what do they mean here, whatever, let me know and I can answer that. He then starts talking to Miss Baker about an exact time, right? Because now we're talking about how did DNA get where, right? If it's not tied to specific activity, then how does it get there? You know, did it blow over there? Did it transfer over there? Like, how did it get over there? And so he starts talking to her about how long does DNA last? How long does DNA last on an item? And, you know, she said you really can't give an exact time. She mentioned something about items being buried for 10 years. But he gets her to say that you cannot say when DNA was deposited. Then they talked about how DNA gets deposited from bodily fluid or skin cells. Okay. And then they talked about, you know, once DNA is on an item, she says with ideal conditions, it could persist indefinitely, but it also can degrade. Okay. I talked to, was on the news talking about degradation of DNA and unknown human remains and cases involving criminal activity and what can we get. And it all depends where it is and how long it's been and all kinds of things can happen because it is biological material. Then they started talking about degradation and how the DNA is, as she described it, a long rope cut into pieces. And if there's degradation, that the degradation, her words, could have been subjected, the DNA or the item could have been subjected to cleaning or high heat. Those were the examples given about what could cause DNA to degrade. And I thought that was interesting. So then the defense asked her, were the samples degraded on the towel and the gun? Right? Above, he was just talking about the normal life cycle of DNA. And so she said on number 8, on the screwdriver, there was some degradation in the peaks, which is on the electropharogram, how they read it. And she would expect all peaks to be at the same height. Okay, so she said there was some degradation. Then on the towel, number 7, item number 7, she said there was slight degradation, but not as much as item 8. Okay, they talked about alleles, how the STR is computed, how they get to the numbering, how they derive whether the person, it is the person or it isn't the person. They gave a great analogy of a bunch of boxcars on a train. It's how the numbering and the amino acids line up, you know, how it gets repeated. And they look at the individual boxcars, okay, on the DNA chain. So I thought that was kind of cool. I hadn't heard that before. So they talked about, and I thought this was interesting too. So DNA is comprised of amino acids, A, C, T, G. And in the STR testing, which is used for CODIS, which they are specifically talking about now, that is short tandem repeats, okay? And that is used for CODIS. And it is repeats of the DNA, right? So they only take, she described it like this, they're not measuring the sequence, which would be all the letters. Okay. Do you remember that? What was that? You know, you had like that string of candy, like those candy necklaces, right? That would be the whole thing. But they're only doing specific sections of it. So she said, instead of measuring all the letters, like all the letters in the alphabet, you're measuring the number of words. Okay. And they got into talking about technology. And she said that not 99% of our DNA we all share. And there's only 1% that is different amongst us. And that is the portion that they focus on. They talked about how you can tell a male from a female. They went back and forth. Like I said, if you want me to go through the whole thing play by play, I can. The defense asked her, did you get a full profile on these items? And so she says on number 7, they got a full profile of the suspected DNA. And on number 8, they got a partial profile. And why did that happen? Well, there could be degradation. It could be that it wasn't detected as they, sourced and ran the DNA through the machine. Or sometimes it can be because you only have a few cells. Now, I'm going to throw this out there. In the Koberger case, if you remember, go watch my videos, they only had a few cells. But they got the whole profile, right? Interesting, right? Okay. So they're going through more technical stuff, talking about the loci. I'm just trying to see if there's anything here. They talked about the difference with Robinson being an 8-9 and Twiggs being an 8-11. And then the defense started asking about rules to exclude, how to exclude somebody. And they started talking about this, started getting pretty interesting here. They started talking about the defense starts whipping out some reports and some books and some experts talking about reliability. This is why I think they're going to get a Daubert or a Fry, talking about the reliability of what she did or what the FBI lab did for this process. Now, the STR has been widely accepted, okay? We just got forensic genetic genealogy accepted, okay? So, do I think it's going to fail on that? No, probably not. But I think the defense, this is a pretty hardy defense challenge on a preliminary hearing. Like, it can get way worse. And I think they're doing a good job at throwing curveballs at the state's. Well, it's not the state's witness, it's the defense witness, but it is the FBI who processed this information. And why do I say that? Well, they're talking about the National Research Council, something about DNA evidence. I don't remember if that's exactly a book. Dr. John Butler, who came from the FBI, he's got 3 current textbooks. They're talking about, don't you read this as part of your study? Yes, yes, yes. Talking about mixtures, that in DNA, you can have problems with DNA dropping in and DNA dropping out, right? Why you may have certain parts of those boxcars, certain parts of that short tandem repeat that are not present. So she said there could be environmental issues, right? Sometimes garbage gets in or dropped out. Sometimes the allele, the portion of it, just can't be detected because of the processing or whatever is going on. Okay. Then they started talking about, and this may be totally boring to you, But if you're interested in DNA and court challenges and defense challenges, I think this is super fabulous, interesting. So again, I can go back and play it, but what they're talking about is they measure when they have those peaks on the electropharogram. It looks like a EKG kind of thing, but it's not. It's these peaks, right? And they showed it in the court. They have this stochastic threshold where they have a certain, the DNA has to hit a certain line before it could be considered, right? If it doesn't meet that threshold, it's too low. All right. And the defense was very interesting here. Okay. So she said that in low level samples, some of the alleles that get copied, which the alleles part of the DNA, could be better than other alleles. All right. So I think they mentioned that I have the number 14 here, and I'm not sure. I don't think necessarily that that's the threshold, but they start talking about the software. So she has guidance so you could get a result that could be anywhere from, let's just say 0 to 100 or whatever, 200. Let's just use 1 to 10, for example. So their threshold has to be a 5. And again, I'm making it up. Their threshold has to be a 5. So if it's a 1, 2, 3, or 4, they're not going to consider it. It has to be 5 or higher. Okay. So then the defense starts getting into concerns with this machine that they use, StarMix. Familiar with that? I've heard it. And the defense starts asking whether reliability has been established. Okay. Daubert Fry challenge coming on. Okay. Just saying. They talk about additional testing, mixtures, and low-level samples. All right. And what happens when they have low-level samples? Okay, so a mixture is 2 people's DNA combined together, and they have to sort it out. So this machine has to sort it out. And that they typically consider it a minor sample below 20%, and that in 3 or more people, when there's 3 people contributing, typically more of them are 20% or less, right? They usually have a major contributor and a minor contributor. Okay. Now, remember we talked about those levels. Okay. So I think the threshold is 20%, if I remember correctly. Well, in number 7 and number 8, the minors appeared to be below the threshold, yet they were used. Okay. So what do we do with that? Is that right or wrong? If the threshold is 20, should you be using it? Should there be a threshold? Should any amount of DNA be considered and worked? Let me give you a good example here, the way I look at this. I can't tell you how many times I hear in forensic genetic genealogy, I heard it in the Nancy Guthrie case, we're just waiting for a bigger match. You just got to pray for the bigger match. No, it doesn't work that way. You have matches. Every match. You have a targeted strategy, but if you run into problems, you're going to work your way through the matches. That's the cop instinct. Every lead gets followed, okay? Every evidence item supposedly gets collected, right? Because everything is evidence. Every match is a lead, okay? So when we're looking at this DNA, this is where I think it's very interesting. You might think I'm crazy, but in this DNA, if it's showing up as a result, why are we limiting it? Who sets 20%? Does that mean that, and there's a report on that, we can talk about that, the examiner's fallibility rate or determination is so skewed that you have to set a parameter? Wouldn't you want to know and look at all the DNAs present, like all the matches? right? Like if you know in the case there's 30 suspects and you only talk to 2 and you decide on one of them, what about the other 28 people? I hope I'm making sense, right? So just good critical things to think about. So they go through more people. Bruce Bedole, DNA expert, used to be head of her unit. Some other people that were from the federal lab, and they talk about. Then we had the state objected to some admissibility because this was going on and on and on. The DNA talk was going on and on and on. But I think it's good questions. But the state was like, look, this is just probable cause. Like, we're not at trial. We're not doing, they didn't say, but we're not doing a Fry or Dauber challenge. This is way too much. And it was a little tedious, but it was interesting. So why, my question is, why does the 20% raise reliability issues? Right? If there's only 2 individuals, right? And that was the defense question. Why? And then here comes the kicker, the shocker. Okay. The analyst, and again, I'm confused about exactly what role Miss Baker had because she does refer to a biologist, and I'm not sure if they just spin it down or whatever they do. Unclear. But it was my understanding, right? I don't work in the lab, that, we've seen it on TV, right? They put the material in, it spins down, it does its thing, it comes out and it produces a report. Well, I thought that the machine was doing all this. No, it's not. It is subject to human error because the analyst determines the number of contributors. And in this case, right? So the analyst determines the number of contributors. And I was like, okay. I mean, no, I knew that, but I didn't think it was occurring this way. And we're going to get more into that. But let me give you an example. Photo lineups. Very challenged here in Arizona, Desert hearing photo lineups, unduly suggestive. Okay. I've been making photo lineups since the beginning of time. And when I had to do it, I had to go take hard copy photos, go through a gazillion files of hard copy photos in black and white, in color, looking for the right colors, trying to make the same people look together. All this. I mean, it was an hours and hours and hours long process, sometimes depending on who you picked. Okay. So now they have machines that do it. Okay. And they do it off of driver's license photos and booking photos. And the machine is supposed to remove the bias and the user error and all that stuff. That the machine is supposed to read the photos, remove the bias, remove the error, and make the photo lineups correct. And part of that is that the detectives are not supposed to adjust the settings, because once they adjust the settings, they ruin the anti-bias parameters. You following? Okay. But no, they go in and they futz with it. Okay. So they just messed themselves up because they've got, then why bother using the machine? Right? Okay. And another thing, I've still seen the machine make crazy errors. And then you have to look and see if the detective futzed with it because it's a glaring error. Okay. So anyway, there's supposed to be a reason to remove the bias and remove the potential for error, that the machine does it, not the human that is fallible and subject to bias. So when I find here, it's up to the analyst to determine the number of contributors. Okay. All right. So the defense starts talking about NIST, right? In this 2024 Forensic DNA Human Factors Report. And they were specifically talking about complexity. And let me tell you, if you know about the Colorado case, I forget the lady's name, that all that nonsense was going on. Sarge's not happy with that, okay? Just not happy with that. I'm just making sure if we're going on. Okay. So anyhow, okay. So they start talking about mixture complexity and, quote, possible contributors. And the defense is asking how those numbers, the 1.7 octillion or 30 quadrillion or whatever that was, how do they get to those numbers? Okay, are you ready? Are you sitting down? It's what the analyst dials into the machine. The machine doesn't do it itself. Okay. So it's like the photo lineup, right? Okay. So it doesn't do it itself. So it's dependent, apparently, on the number of contributors that you tell it it has. So it's not reading the DNA itself. It's not calculating the number of contributors itself. It's taking the number that you give it. And I'm going to say this part now. If you change it from 2 contributors to 3 contributors, you get a different output. It gives you a different set of numbers. And what do those set of numbers do? They identify the person. Okay, it matches a person. Am I making sense? So it's like if you give somebody the wrong social security number, if you give someone the wrong bank account, they're going to put your paycheck in someone else's account. In this thing, if you get the wrong number, the hit is going to come back on another person. And the computer isn't doing the thing. The human is dialing in the 2 or the 3 or the 4 contributors, and then the machine does its thing. Okay, you ready? You ready? Okay. She originally thought there were 3 contributors. And so she dialed in the thing with the 3 contributors or whatever, did the thing with the 3 contributors and got the output. Okay, but there was only 2. Apparently, we think that 2 is the final decision. Okay, again, I'm just listening to the testimony and forming my own opinion based on the testimony. So, back and forth, back and forth, back and forth. Everybody's getting involved. Okay. So I'm trying to read my notes here and think about what I'm talking. So it seems that it's unclear that visual inspection, I believe this was that report, okay, that it is unclear if visual inspection renders a consistent number of contributors across analysts over time. So if this is a science and there's standards, and right, the thing, and everybody's following the same standards, we should, scientific testing and stuff, we should get the same results, right? Well, apparently, according to this NIST report, they didn't find that. They didn't find that. Okay. I'm like, oh, okay. Like if you give 100 cooks, chefs, a cheesecake recipe, what do you think? 95 of them should taste the same and look the same? I mean, look, don't they have that Gordon Fox, that Chef Ramsay, and they just taste the thing and they have to figure out what's in it and make it. Okay, so like they could do that, right? But if you give 100 chefs the same recipe, what do you think? The odds should be of it coming out and their standards that it should come out right every time. What do you think? Right? Would you get in trouble for that in your job? I mean, I'm just asking. Okay. So, she says, right? So they're going back and forth about this report. Is there consistency? Is there not consistency? And she says, quote, "We never truly know," end quote, "the number of contributors." and the contributors affect the output of the thing. So she says she follows the quote best determination based on the DNA evidence I have. Okay, and remember I said if you change the number of contributors on the machine, you're going to get a different answer. So she said, they talked about this thing about getting a different answer. And she says, well, it's made that way because it uses math and it outputs, I don't understand this, it outputs different things, but it uses math. And it's going to give you a different number every time, even if you run the same sample with the same number of contributors. Apparently, from what I understand from the testimony, it's going to give you a different number every time. I don't understand that. Okay. She said it shouldn't differ by more than a factor of 10, which I don't know what that is. That sounds really high to me. She said it doesn't change the likelihood ratio. Oh, so this is the thing to get the likelihood. This is the thing to get the quintillion, octillion. Right? It doesn't change the likelihood ratio, quote, by much. How much is much? If you are a defendant, and again, we're not on either side here, we're just learning, how much is too much? Wouldn't you expect it to be run and get the same answer every time? What's up with that? I don't know. Okay. And so I said here, I wrote my note, no more than a magnitude of 10. So I said, 10 quadrillion, 2 quadrillion, like how much is too much or not enough when you're the identified suspect? I mean, these are all great questions. So then the defense, see, this is why I said we need a long video to talk about this. The defense was talking about the technical reviewer's notes because she originally had 3 contributors. Then it went to technical review. And the technical reviewer said there's only 2. And then it went through again and it ended up at 2, even though it went to the technical reviewer. The technical reviewer said 2, then they talked about it, then it was 3, and then it ended up at 2. Remember, every contributor changes the output. Okay. Then they were talking about how the electropharogram was not part of the star mix. They said, which I thought was interesting, that prior to her testimony, the defense did meet with the state and they did talk about all this testimony. So this should not have been shocking testimony or shocking questions for her. They went through why she concluded 3 contributors. She was going to go through that and stated that the electropharogram was the last step in the process. Now, okay, here's what she's saying. So those peaks, right? Those peaks on the report, here we go again. She's the one that sets the parameters. Not the machine, not the software, her. Okay? They say that during the validation of the machine, they set thresholds for stochastic and analytical, and that they use 150, and that any peak greater than 150 will show up and less than 150 will not. So I will go again to, do you want to see everything that's there or do you only want to see part of it? I don't know. I don't have an answer for that. I want to go in. I really want to go into the lab and see how to do it. So she's going again, talking about how looking at this electropharogram, there should be 2 things there. One you get from mom, one you get from dad. And that if she sees more, that's a clue or a hint that something's wrong and there may be more contributors. And so then they have to go and figure it out. She said that on September 12th, she decided that there were 3 people, but then it changed on September 13th. Okay, ready? Sit down. She was given an elimination sample from Twiggs as a known contributor, that she was to expect that his DNA might be present. Okay, do you catch what I'm saying here? Again, we're not playing sides, but we know, let's go back to the result, that quadrillion thing. We know from that report that in 7 and 8, Twiggs was present. Okay, identified as present as a known contributor. And the other possible person was Robinson. So how does Twiggs become an elimination sample and not a suspect sample? I'm just asking. Right? Like, do you get where I'm going here? So she's running tests the day after, 2 days after, and she's running them 24/7. And they're like, find the answer, find the answer, find the answer. Now, Robinson has allegedly confessed. But then here's Twiggs' DNA, and they're like, he's just an elimination. And that word is big, okay? Elimination. And she goes in to describe, as a cop, you normally at some point in your career are going to have your elimination prints on file, because you walk through things, you touch things, especially if you're working in the lab, working in the crime scene and all that stuff, because inadvertently it can get anywhere, okay? Contamination, you don't want it to happen, but it could happen. That's what elimination is. All right? So Twiggs is automatically an elimination sample. Now, I know a little bit more today from what I watched, but I'm going to leave that here. At 3 days after, should somebody automatically be an elimination sample? And I don't want to use the word safe, but I don't know what else to call it, right? Like we know the cops were at the scene, so we're going to put the cops' DNA in there. And then if the cop and some other person comes up, hopefully, the bad guy's the other guy, right? But there's 2 people present, okay? But Twiggs got submitted as the elimination sample. That word, look at that word. Okay. So he says, well, how did that happen? How did you come from 322? So she says, quote, in talking to the investigators, it was decided, and you guys, I always use the word semantics. It was decided that Mr. Twiggs should be used as an elimination, end quote. Let me repeat it. In talking to the investigators, it was decided that Mr. Twiggs should be used as an elimination, end quote. So they continue and they say, okay, so how do you know that so you got Twiggs and Robinson. How do you know that there's not a third person? She says, because when they compared the 2, no DNA was left. Okay, so no other DNA was present. And she described elimination like, if you have a stolen vehicle, you might get submitted the vehicle owner's DNA as elimination. Okay. So then the defense asks again about this conversation with the investigators, and she says, quote, I talked to them with regards if I should utilize Mr. Twiggs as an illumination versus comparing him and offering him as a statistic. Okay. Now, the statistic is that octillion. Okay. When we get results for a potential, we can't even say, according to their language, you can't say a potential identification. But when we get a lead from the lab, from STR, it usually comes as that octillion-y, septillion-y, huge number, okay? Which is not an identification. Remember, now we have to go all the way back to the front when I started with that other DOJ document that you can't make an ID. You cannot definitively say that that septillion probabilistic genotyping, whatever it is, that cannot ID someone. Okay. So it was decided that Twiggs should not migrate through and be on the report like that. Make sense? He was only elimination. Only elimination. So the defense talks about the report, her report, and he's talking about how she, quote, concluded. The defense is like hammering, really good. In the report, you concluded that one of the contributors to both samples was Twiggs. Okay, so now remember, in the report that has the octillion-y, right, those statistics, the probabilistic typing of Robinson is probabilistic. It can never be 100% anything related to, it's just a here's the number, which comes from putting other numbers in, okay? It's only a possible. Now, the defense was like, okay, so I understand this guideline and all this stuff, and you can't say this, that, or the other, and you have this number, and here's this number that says it's possible that it's Mr. Robinson. But in your report, you said the other person was Mr. Twiggs. Positively Mr. Twiggs. So the defense is saying, how can you say it's possible over here, but we're 100% over here? Which is a good question, right? So she says, quote, knowing there was an expectation, that's a word, that his DNA could be present, when I compared him to the DNA sample, I did see his DNA types present. So using the word assumed, that's verbiage that we use when we calculate our statistical calculation. I'm letting the software know I know this individual is there, or I'm assuming that they're there. Now, we don't know which they're there she's talking about. Is it they're there in the DNA, or is it they're there at the there? You know, like the crime scene there? That's what she said. Letting them know that we're there. Based on my comparisons, I did see evidence that the person was there. Now we go back to that activity thing. Again, semantics. So is that person is there in the mixture, or they're there? So the defense is like, I'm confused about the language, how it should not be absolute. And she says, well, with elimination samples, that's different. That's different. Okay. She gave an example of sexual assault, So she said, for instance, if the victim of the sexual assault, a female, has a regular partner who is not the suspect, then that partner becomes a known elimination sample. Okay. And then the other foreign DNA becomes becomes the suspect. Okay. And that foreign DNA would get the octillion-y statistical thingy on the report. Okay. But the other two people, the victim and the known boyfriend, are known. They're ID'd 100%, but the other statistical one isn't per the guidelines. Okay. So then the defense says, why do you think it was expected? And she says he was a roommate and that items came from Mr. Robinson's home, the towel in the home. And so she said, quote, it was important to assume potentially Mr. Twiggs' DNA was present. They went back and forth about the towel being found outside the home. And she said that there was information to suspect that the towel came from the home. They talked about various STR runs with a number of contributors. And then this was interesting too. Are you sitting down? This is crazy. Okay. They talked about this likelihood ratio, right? The octillion number, the probabilistic number. And the defense says, what is an HD and an HP likelihood ratio? And she talked about that's how they set up the STR mix to provide the output. And that HD is the defense hypothesis and HP is the prosecution hypothesis. Okay. Remember, we're trying to get to that. She's trying to get to that number so she can say included, excluded. Okay. That it's possible that this person is included or possible that they're excluded. Okay. So then they put in the number of contributors, right? She's got to dial that in or put that in. And she says that it is, quote, the likelihood ratio compares the probability of seeing a DNA profile given one of two different scenarios or explanations or hypotheses. One is that a particular person of interest is a contributor, and the other is that an unknown, unrelated individual is a contributor. Okay, so the prosecution one is the contributor, right? And the defense theory is the one that it's some other dude did it, right? Or some other dudette did it, right? So she says, quote, so depending on the question being asked is how I set up the STR mix, end quote. Again, human interference. Quote, for example, if I'm utilizing someone as a known elimination sample, I will apply their DNA profile both to the HP and the HD. My tools. So we have this thing that they're assuming to make this probabilistic rating. They're assuming this HD, HP, which is funny. They're calling it prosecution and defense, and the defense challenges. The defense says, how do you even configure the HD, the defense hypothesis, when you don't even know what it is, right? Because no defense attorney, you don't even know who the suspect is. So this is me talking. You don't know who the suspect is. The case hasn't even been to anywhere because nobody's been arrested. Nobody's been identified as a suspect. So how do you know what the defense posture is, that it's just going to be somebody else? I just thought that was fascinating. And so the answer here is the defense hypothesis is simply the DNA profile, the probability of the DNA profile, given that another unknown, unrelated person to the prosecution's potential person of interest. Okay? So there's an assumption there, it sounds, that just because they're testing somebody as a suspect, that person is the prosecution's potential person. And so the defense's potential other person would be somebody else. What do you think? Right? All kinds of crazy questions here and stuff. Okay, the next thing we're going to talk about is a discussion about agent, I'm not sure, Officer Folger gave an update, or she gave an update, and it was decided, this is Miss Baker, that additional statistics needed to be run, that she had only run twigs to sample, and after discussion with the tech, they decided to calculate twigs by himself. So that means getting that statistical percentage like we saw with the octillion, quintillion, or whatever with Robinson, so that twigs would be alone, okay? So going back to, so then they're going to pull up this report, and so the defense starts talking about the report, the inclusion report, the statistical report from the star mix. And Miss Baker says that she did not utilize this calculation for Mr. Twiggs, that she used visual examination only, and that she didn't really have any standards about what she could use, that she could decide what she was going to use, and that she, quote, assumed he was a contributor, right? So she's intimating here, I believe, that she didn't need to see the report with the quintillion, octillion, or whatever, because she assumed he's a contributor. So she's assuming that it's him. And so then they brought up this scale, and they showed this likelihood ratio that over 1 million is very strong support for inclusion. 10,000 to under 1 million, strong support for inclusion. 100 to less than 10,000, moderate support. And 2 to less than 100, limited support. And 1 was uninformative. Well, guess what Twiggs's ratio was? 1. But she's still certain that it's him because she was told that he was an elimination and he was a contributor, and that she visually looked at the I'm going to get it right. I'm going to say echocardiogram. It's just not what it is. Electropharogram or whatever it's called. Okay. So like crazy town, right? So the defense says, well, you relied on the star mix for possibly including Mr. Robinson. So like it's good enough for that, but then it's not good enough for Twiggs, right? Twiggs comes up uninformative. And she said, quote, she used her own knowledge and training, end quote, and that there's no standard. So he says, the defense says, well, you just disregarded it. And she said she can't say she disregarded it, that she typically uses star mix to give weight to inclusions, meaning suspect profiles. But eliminations are different, okay? We're starting to see that eliminations are treated differently. She says, quote, if I'm told that if I'm told that an individual is submitted as an elimination sample, I can assume, there's that word, that they're there. Usually, I am able to look at the DNA evidence and determine that, yes, I think there is enough evidence All right, phone rang. I don't know if you heard it or not, but I'm back. Okay. So we were talking about, how they could use this star mix for Robinson, but they can't use it for Twigs, right? Because of this number, this low number. And so, she says, well, she really didn't disregard it, right? She said that she has to assume um that the person is there, that the evidence is there because she's told that that is an elimination person. Then they talked about some loci locations that that numbers were present, numbers were not present. Um, so for instance, there's supposed to be two numbers and there was only one number. And then she said something to the effect of, quote, the only piece of information recovered at that location. So like when he said, well, what about there only being one number? She was like, well, that was the only thing that I got at that location. He then started talking about a textbook by Butler, asking her, if it fails to match if it fails to match in all areas, you have to declare it a non-match, right? And she said, quote, I would agree with that in a single source sample, but not in a multiple source sample. And then they start going through these different loci areas. Was there a 14 and 16 on number 8? No. Was there a 7 and 9.3? No. So he asked her what she did, and she said, I ignored that location. Then they talked about evidence that there were more than just items 7 and 8. There was a backpack and items from the backpack, and that she initially had no information on those. So they started testing the items. But then, as the investigation continued, it was determined to be left behind by a bystander or one of Kirk's detailees, therefore, no testing. They also talked about destructive testing, that that's the process when they use all of the material and there's nothing left, which is not good for any type of confirmation testing for the defense during the trial and for post-conviction relief, right? If you're accused of something and somebody says they have DNA on you, don't you want to test it and make sure you get the same results? I would, right? You say, show me the evidence. Let me examine the evidence. And when you do destructive testing, they have a destructive testing policy. That means they can consume the whole sample. So she said she has to request that, but that is their process. And so that would be, for instance, with the Q-tip, the swab, that instead of only taking a portion of it like some labs do, they just take the whole thing. And there may be DNA liquid left. Okay. Right. So then they talked about certain samples that were consumed. They talked about items 1 through 6, a swab from a smudge, a swab from a hand swipe, a swab from sweat, a swab from smudge, a swab from smudge, and a swab from sweat. And she found in those samples no DNA present. And I don't know exactly where that area was. She did talk about, I think, let me correct myself, something about the railings in the stairwell. when I hear smudge, my mind goes to that scrape on the building or that scuff on the building, but I could have the wrong area. So she says in that they used 10 microliters of DNA liquid, and they had 3 microliters left, and she was unable to get any DNA from it. And so the defense was saying, well, if you didn't get it from 10, we're probably not going to get it from 3, right? The defense is looking for anything that might show some other dude did it or dudette did it. They also talked about item 54, 55. This was the stairwell railing. And the defense pointed out, which I hate when they do this. I've had it in my cases. They combine, I call them Q-tips. They combine the Q-tips from different areas. And I cannot stand that. I had that in one case. I cannot tell you what the item was, but the item is a piece of fabric. It's like about this big. And they took the DNA from multiple areas on it and combined it. And then guess what? It's a freaking mess of a mixture. Well, of course. Okay. So I hate that. What did they do here? They combined it. It's the policy. And guess what? It was a mixture. They couldn't get anything because it was too many people. Okay. So she, quote, could not produce a conclusion, end quote. They also talked about isoalleles, the fact that they only look at the number of boxes, not the sequences of letters inside the boxes, the amino acids. Then the state came, the judge was like, this is taking way too long. This is only a preliminary hearing. You gotta, hop to it. So the state came on, the judge said something, the state came on, and they went through her background, that she has a bachelor's of science in biology. She was an FBI lab contractor. She worked in the federal conviction program. Then she became a biologist where she did the testing. So remember I had that question where who was actually doing the testing and who was doing what. So she started out doing the testing, and then in 2015 moved up to become a forensic examiner. She talks about the ANAB accreditation for the lab, talking about the procedures that she went through a 2-year training program. She did a moot court competency exam. She does proficiency testing. And then the defense was asking, or I don't know if the defense or the state asked this, I apologize, how many labs use the StarMix machine? And it's only 120. So to me, that seems a little low. We've got 50 states. If we only had 2 crime labs in each state, no, yeah, 5 times 20. What is that? Am I adding correctly? 5 times 20, what is that? It's the end of the day, folks. I can't. Yeah, 100, right? So it seems like we would have more crime labs than that. So I don't know. There's always competing technology. Then the state came on. The state was talking about the directive, that the directive is the directive that limits what she can say, what she can't say, her conclusions. And he said he got her to explain that the DOJ puts the directive limits on the verbiage so that the reader can describe how they want to interpret the numbers. I don't know. Do you want to interpret the numbers, or do you want an expert to interpret the numbers? I don't know. They talked about, he went through that the 1.7 octillion on the towel was, quote, very strong support. The 30 quintillion on the screwdriver was very strong support. They talked about the formal activity level, that, she can't tell who did what or what activity was related to how the DNA. and they talked about how DNA gets transferred and all that. So that's where the DNA portion of day 2 left off. Lots of great questions. As I mentioned, I am not a biologist. I am looking at it from the prosecution side, from the defense side, from the potential jury side, and all good questions, right? I think the defense is really honing in on a lot of things, probably going to be some challenges. I think there was some very interesting things for me to look at, things that I want to be definitely more knowledgeable of. And from a, if I was the prosecutor or if I was the defense attorney, how do you overcome all of this human factor that seems to be in this situation, right? I 100% believe in DNA and the science, but it was interesting to me to hear what they were going after, why they were going after, and how much human factor and potentially human error could be there. So I'd love to know what you think. I know it took a long time. Thanks for being here again. If you like what I'm doing, I would love it if you would subscribe. Thank you for everybody that's left such great comments. Even the haters, that's okay. I know I'm not for everybody, but it's my mission to learn more for me, learn more for you, and get this work done so I can help the humans and we can solve these cases. I saw somebody in the Court TV comments that was talking about we've got to get all this backlog solved. It's untenable, okay? The delay that the FBI was talking about, 180 days, too long, or 200 days, too long. In my town, my local area, we've got 3 years of backlog just on sexual assault kits. Unacceptable. We need to fund our agencies. We need to get all this stuff going, and every police department should be doing forensic genetic genealogy. That's just my opinion. If you have a question, you got a question on a case, leave it below. Love to see you on a live. But thank you so much for the support. And I'm going to head over to day 3, and I'll see you on the next one. Thank you for being here.